Okay. Very good afternoon to all of you. From our side, I'm really very sorry due to some technical glitches. We had to delay the session by few minutes. It is my absolute pleasure to welcome today's guest speaker of the day, Dr. Mayuriben Pandya. One book, 25 parts, for 470 articles, and 12 schedules. Does it strike which book I am referring to? Or does it ring any bell in your minds? Well, I would say you actually live according to that book. I'll repeat, we all actually live according to that book. Here I am referring to our very own Indian Constitution. At GLS University's Faculty of Commerce, SMPIC, it has been our constant endeavor to nurture young minds and inculcate new thoughts and ideas. What better than making this millennial generation study the subject Indian Constitution as a part of the foundation course? With the motto of molding minds and shaping careers, our director, Sir Dr. Amy Jokhi, had an innovative thought to begin a lecture series by the name of Academics and Beyond, whereby we invite subject specific experts to talk to our students on various contemporary issues relating to commerce, management, law, accountancy, auditing. It has been his constant efforts and encouragement that we have been able to organize such webinars successfully. May I take the privilege to invite our dynamic leader, Dr. C.A. Amy Jokhi sir, to say a few words. Over to you, sir.
Good morning. Thank you, Ashal ma'am. Good morning, Dr. Mayuri ma'am, and good morning, dear students. Dr. B.R. Ambedkar, the first law minister and justice of India, and we all know him as a father of Indian Constitution, very rightly said that cultivation of mind should be a constant effort, and it is very important for the human existence. And today, in this session of Indian Constitution, from all faculty members from Faculty of Commerce, we express a profound thanks and a heartfelt gratitude to the learned speaker of the day, Dr. Mayuri Pandya ma'am. Dear students, just to share that when we were thinking of that whom to invite for this topic and the session, the first name definitely which came to our mind was of Dr. Mayuri Pandya ma'am, but we felt that being a director at the law college and with a various national committee, member of national committee, she is extremely having a busy schedule, a hectic schedule. So we were thinking that we will try and request her. So with that thought, I called up Dr. Mayuri ma'am that Mayuri ma'am, we are planning to arrange a session. We know that you will be definitely busy and hectic. So can you suggest your faculty member name? Immediately Mayuri ma'am said that no, I'm not going to suggest any name, but I'm going to take the session. Mayuri ma'am, thanks a lot, ma'am. I'm sure that today it is going to be one of the best session in this academic lecture series. I'm not going to take much of the time, and really apology to all the students also because we had some technical issues. And Mayuri ma'am, thank you very much. Today's session is going to be a great learning experience, a motivational session. And again, I thank on behalf of all faculty members from Faculty of Commerce to spare your time for taking this session. Thank you, Mayuri ma'am.
Thank you so much, sir, for your kind words. Yeah. In the words of our Prime Minister, Shri Narendra Modi, our Constitution is a ray of hope, where H stands for harmony, O stands for opportunity, P for people's participation, and E for equality. With this thought in mind, as Sir rightly pointed out, that we thought of inviting Dr. Mayuri-Ben Pandya, Director, GLS Law College, to give us an overview about our Indian Constitution. With a degree of PhD in law, a gold medal in her master's law, and many books and research papers to her credit, Dr.
Sorry,
Mayuri-Ben, yeah,
I'm sorry, Ashalban. There
yeah,
is no need for any introduction.
yeah, just a
There is
moment.
no need for
Yeah, yeah.
any introduction. Thank you.
Yes, yes, yes.
And
Just
I
a
think
moment.
due to technicalities, already lot of time
Yeah, yeah,
has
yeah. No, 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 ma'am.
wasted.
It's your
So
humble
thank you so
humility,
much
but
for thank you so
yeah,
much for inviting me.
yeah.
I would like to interact with the students on the
Yeah, yeah,
subject.
sure.
Uh,
Just on
Just
one
only
note, ma'am.
I will give my introduction to myself, to all the faculty members and all the dear and
Yeah,
the soul of the SMP College, all the
yes,
students.
yes.
I
Thank
am Mayuri Pandya and I am a law teacher. I
you.
think
Yeah,
this introduction is sufficient
thank
and
you.
look forward to all of you. I always believe, Ashalben, now I am with my students, so
Okay,
don't
fine,
worry.
ma'am. Fine.
And as a law teacher, I always believe that whenever we start learning any of the subject, we know we always, in law, we always file a caveat. It's something that when you file a caveat means I am saying that no caste, no creed, no religion, no sex, no gender. We, as the citizen of this country, we, as the human of this globe, we, as a one human in the entire world, without any sort of biases, we want to learn something, we want to understand something, we want to understand our own foundation. And when we talk for the law, the very first question as a student that come in our mind, you know that the today's subject is an overview of the Constitution of India. Or you can say the law pertaining to the Indian Constitution. The one very first question that always come in our mind when we talk for the law, what we understand by law? What is the jurisprudence of law? What is the definition of law? As this is a virtual mode, it is not possible that you can talk to me or you can answer my queries and my questions. But as I said, no caste, no creed, no religion, no sex, no race. As a responsible citizen of this country, we will try to understand what the law is first, and then we will go to the supreme law of the country, that is the Constitution of India. And I think that at the end of this session, you will understand that why I am saying no caste, no creed, no race, no religion, nothing. With the word law, the another word which is very known in our circles, the one is right. And nowadays, you know that we are very conscious for the rights. So another important question that all of us we need to ask ourselves, that is what we understand by right. And I think when we talk for the right, the one of the most important aspect that we need to think for, and that third one is the duty. So on one hand, you have your rights. On another hand, you have your duties. Now, as a layman, for example, I am not a law student, I am just a layman. How many questions will come in my mind when I want to have an overview of the Constitution of India. What is law? What is Constitution? Why Constitution is required? Suppose if there is no Constitution, then is there any other countries who are not having the Constitution, and even though their country is run? These kind of questions that may come in your mind. What are my rights? What are my duties? All these kind of questions that will come in your mind. Say, for example, tomorrow the government of Gujarat declares that if you want to visit state of Rajasthan, you have to take a prior permission from the government of Gujarat. One. And also you need to pay 1,500 rupees while entering the state of Gujarat. What will be your reaction as a common man, as a student? What will be your reaction to this kind of situations? Please try to understand only the questions. What are the things that we need to think? I'll give you another example. Your own institute, your GLS University declares tomorrow that from tomorrow your classes, your lectures will be from morning, midnight. At night, Joki sir will announce tomorrow that the GLS University has passed a resolution saying that the classes at SMP College from tomorrow will be midnight. What will be your thought process as a student of SMP College? Just think of that. For that all to answer, we need to understand first the supreme law of our country, and that is the Constitution of India, which came into existence in the year 1949 on 26th of November, and that is the reason that we celebrate that particular day as a constitutional day. It's a Constitution Day because it came into existence on that day. And the Constitution of India, it was implemented on 26th of January 1950. That was the year, the day where that we celebrate 26th January as a Republic Day. Now, what is the need for the Constitution? Why you need Constitution? What are the different characteristics of the Constitution of India? What is the meaning of that? All these things we will understand when we start the presentation formally. You also will have many questions in your mind. Would like to answer all your questions and the queries. May I request Ashilban to switch to the presentation, please?
Yes, ma'am.
Ashilban, can you see?
Yes, ma'am. PPT is now seen.
Okay, thank you. So this is, friends, you can see here, you can see the slide properly. I hope that. An overview of Constitution of India, which is one of your foundation course. I have learned that your syllabus is divided into the 4 units. That is the broad framework of the Constitution of India, the philosophy of the Constitution, Constitution as a living document, fundamental rights, directive principles of the state policy. Unit 2 is pertaining to the ordinance making powers of the President and the governors, legislative powers of union and states, judiciary, writ jurisdiction of the High Court and the Supreme Court, different types of writs, concept of delegated legislation, freedom of trade, commerce and intercourse, and the constitutional provisions relating to the state monopoly. Now, these are some of the topics which are part of this particular foundation course. What I will do is I will try to cover as far as possible within the given available time slot. This is the Constitution of India. Now you know that. Supreme Law of India. It came into existence. Existence was in 1949, but implemented from January 26, 1950. And this is the longest written constitution of any sovereign country in the world, which contains the 448 articles, 12 schedules, 25 parts, and 104 amendments as on date. Friends, these are the few of the salient features of the Constitution of India. Now, each point we will discuss in detail. The lengthiest constitution of the world, the establishment of the sovereign, socialist, secular, democratic republic. If you see the first and the foremost part of the Constitution of India, that is the preamble of the Constitution, which starts from the we the people. So this is the Constitution constituted by the we the people, and it has been also given to the we the people. So the core, when we talk for the democracy, this is the country which is by the people, of the people, for the people. And when we refer to the sovereignty here, if you see the first sentence of the preamble and the last sentence of the preamble, that is because ultimately we have given and to us we have given. So that is the sovereignty of the people, and that's why we say it's a republic. Ultimately, the government which is in power, but the government is in power. That right to vote is ultimately with the public at large. So we the people, and the sovereignty of the state. India declared as the sovereign state, that we have our own government, and the government itself, government has its own sovereignty to the territory of the country, and that sovereignty makes the government. It's a sovereign state in context to, if we say, to the under the international law. The another word which is also added by the 42nd Amendment to the Constitution of India, and that is secularism. So India is a secular state. So secularism, democracy, socialist, republic, justice, liberty and fraternity. These are all the the goals that you find under the preamble of the Constitution. We will discuss in detail with examples, but this is just at a stage, just to go through the salient features. The parliamentary form of the government, parliamentary versus presidential system. There is a unique blend of rigidity and flexibility you find. The fundamental rights, directive principles of the state policy, a federation with a strong centralizing tendency, adult suffrage, independent judiciary, secular state, single citizenship, fundamental duties. There are many landmark judgments on the fundamental duties as well. Judicial review. These are all the unique features of the Constitution of India. What is the need for the Constitution in the democracy? It lays the strong foundation for a parliamentary democracy to function. It's the supreme law of the nation, the largest democracy in the world, and the Constitution serves as a guiding light.
Yes, ma'am. Now, need for the Constitution, that slide is there.
Salient features?
No, need for the Constitution.
Can you see?
Yeah, need for the Constitution in the democracy. That slide is visible.
Okay. No, that's fine. So I hope you can see the slide, Ashalban.
Yes, ma'am. Need for the Constitution in the democracy. That slide is visible right now.
Okay.
Yeah.
So India being the largest democracy in the world, and the Constitution serves as the guiding light for its function, that it can work smoothly and vibrantly. And ever evolving, the Constitution of India is always dynamic, and by the time there are 104 amendments till the date that has come up. So to address the changing needs and the requirements of any of the, say, the developing nation, so India has so many amendments under the Constitution of India as the need changes, and it is always said that when there is a change in the society, so this is also one sort of a social transformation. So when the society changes, the law also changes. But I feel that it is vice versa. At times the law changes and the society also changes, but more of whenever there is a social transformation, whenever there is a social change, it has the impact, the direct impact in so far as the law is concerned. So it is very essential to, with the change of the time, it is needed that to amend the Constitution of India. What is the Constitution? I hope you understand that for any of the government, ultimately you need the guiding principles, and we always need to have some limit, because if you see the Constitution, it has a main two aspects. The one is the relationship of the different levels of the government, and it is the government and the citizens' relationship as well. So the guiding principles and the limitation, that also you find that is how the functioning of the legislatures, or the functioning of the judiciary, or the functioning of the administrative authorities, all the three important wings of the government, how they will function, and what will be their rights and what will be their duties. So the guiding principles, and not to certain extent, it is the limit. Because, for example, if any of the government who is in power, Lord Acton has said that power corrupts, and absolute power corrupts absolutely. So you always need to have a check and the balance system. You need to have some limitation. So even if I am whichsoever the party is in government, but the government is also subjected to the rule of law. You are answerable under law, and that is the law, the supreme law of the country, and that is the Constitution of India. So basically the Constitution of India is, we say that it is the supreme law because any law which is passed by the government in power, it has to be in consonance with the Constitution of India. Because if you see the whatever under the preamble, whatever the object of the Constitution is, for example, let us talk for only one aspect, justice. Then it is envisaged that the justice has to be socio-economic, political. Now, if you want to achieve the socio-economic and political justice, now, if you wish to achieve that, you need to have certain rights also to achieve that. And that is the reason that you find that there is a fundamental rights part. So when we say that there is a rule of law, that means that is the limit of the power vested in you as a government, whichever the limb of the government you are working with. So any law which is passed by the government, by the legislatures, it has to be in consonance with the Constitution of India. This is the fundamental cardinal principle. And that is where the limitation of any of the government who is in power. We as a citizen of this country, we have always right to challenge it. So there are remedies as well available under the Constitution to that effect. So I hope you understand. I understand you are not the law students, and this is general. This is more of the part of the legal literacy to the literates. I'm very happy that this is part of your curriculum, and I congratulate Joki sir that this is, I take it as a legal literacy, because even if you are a literate, but you are not legally literate. So being that this particular course as a foundation course is, I really appreciate your director sir for having this particular paper, because any law which is applicable to you, ultimately you find the source of everything under the Constitution of India. Like say for example, if tomorrow, if the government of Gujarat wish that tomorrow the telecom and railways and all the laws will be passed by the state legislatures, the Gujarat Assembly will pass the laws. They can't. Why they can't? Because the Constitution says so. There is a schedule which is particularly specifies that on which particular subjects the parliament, the central government is empowered to make a law. There are specific entries given to the state list on the subject on which the state can enact laws. And there is concurrent list also, wherein you find that on those subjects, both the central government and the state government can enact a law. So, but ultimately, every law or any order even passed by the administrative authority, any ordinance passed by even the President of India, any ordinance passed by the governor of the state, it has to be in consonance with the Constitution of India. So now when we say that it has to be in consonance with the Constitution of India, what does it mean? It means that whatever the rights, whatever the fundamental rights and the constitutional rights, one cannot abridge the fundamental rights enumerated under the Constitution of India. So again, the need for the Constitution, that it has to be in conformity with the Constitution of India, in consonance with the Constitution of India, and the working of all the three functionaries of the government, how to function and what is the limit, and that limit we call as a rule of law. You cannot announce to have the lectures midnight. Again, anything, any part which is the most important part of our lives also. There are many aspects in our lives also that we find many aspects that we find in our life as well that we don't find. So again, the relation between the different levels of the government and between the government and the citizen. We need a constitution to govern our country properly. You can just go through this particular slide, whatever I said earlier. So the constitution is required to have authoritative allocation of power and function, and also to restrict them within its limit. And that is why we say that there is a rule of law. Now, for the framing of the Constitution of India, there are different parts of the Constitution that we have borrowed from these features are borrowed from the different constitutions of the nation. You can see in the UK, from UK we have the parliamentary type of the government, bicameral parliament, lower house, more powerful council of ministers responsible for lower house, provision of the speaker in Lok Sabha. From USA we have, of course, UK has no written constitution. Here you can see the USA having the written constitution, the appointment of the vice president, fundamental rights, the Supreme Court, judicial review, all these we have borrowed from the constitution of the USA. Then you can see here from Australia, we have these concurrent list, the list which I referred just now. I told you that the concurrent list, the center-state relationship, the language of our preamble that we have borrowed from the Australia, the fundamental duties and the 5-year plans and all that we have borrowed from the USSR. The emergency provisions that we find under the Constitution, that is from Germany. The law on which the Supreme Court functions, that we have borrowed from the Japan. Because see, at the time of when the Constitution of India was constituted, you know that if you look into the history, that there was the Constituent Assembly and the Constituent Committee who drafted these particular constitution. And at that time, because our constitution came into existence in the year 1949, implemented in 1950, but before that, at the United Nations, there was a declaration of the Human Rights Charter in 1948. You must be aware, in your college also you must be celebrating the Human Rights Day, that we celebrate it on 10th of December. Because on 10th of December in 1948, the there was a declaration of the United Nations Human Rights Charter. And that Human Rights Charter, many of the rights of the under the human which were declared, that is also the part of the, as far as possible, that is also has been taken up under the Constitution as a part of the fundamental rights. Few of the rights are also been taken under the directive principles of the state policy. But before we go into the details of that, first, this is whatever the scheme of our Constitution, if you see, that we have borrowed the best of the best from while they studied the different constitutions which were already in existence at that time, and the best of the best part was tried to get. The concept of the directive principles of the state policy, that was borrowed from the Ireland. So these are the few of the countries from the constitution of them we borrowed that. Now the nature of the government, it's a federal, unitary, but if you see the functioning of the government in India, you find that it's a quasi-federal nature. Now here, when we talk for the federal government and the unitary government, you will find that this is what the difference is: a dual government. For example, we have at the central level and the regional level the single government, that is national government, which create the regional governments. Written constitution. In case of unitary government, the constitution may be written or unwritten. As I told you earlier, in Britain, it's unwritten constitution. Whereas if you take up the USA or France, you find the constitution written. Division of powers between the national and the regional government. As I said, few of the subjects which only the state government can enact the laws. Some of the subjects only the parliament can enact the laws. Supremacy of the constitution. This is what the difference is. You can rigid constitution, independent judiciary, the bicameral legislatures. Now we move forward with one of the most important part of the constitution. When Ashalben today started, she said that the Constitution of India divided into 448 articles, divided into the 12 different parts. Now 12 schedules and 22 parts, but now it is 25 parts. But the most important part under the Constitution of India that we find, we as a citizen of this country, we enjoy the fruits. So the most important part is the fundamental rights. Because these are the rights that if these rights are abridged, then it empowers you to go directly to the apex court, to the highest court of the country. So the remedy that you find under Article 32, that is also your fundamental right to go before the highest court of the country. And that's the beauty of the fundamental rights, which empowers an ordinary person, citizen, to go before the Supreme Court of India. Here I said that an ordinary person. So this is also one of the very important aspect that we need to understand as a citizen, that whatever the rights enumerated under the Part 3 of the Constitution of India, all those rights are available to the citizens of the country. But few of the rights are also extended to the person in this country. That means there may be the few of the people who are not the citizen, and even though they are visiting, say for example as a visitor they have come here, or say for example some aliens, that means a student who has come here for the study purpose in India, So, of course, those who are not the citizens will be considered as the aliens. Under the international law, it is considered as an alien. But then as a person, as a human being, as a person, you have certain fundamental rights are also extended to the person also. So, few of the rights are strictly only to the citizens, but most of the some of the rights are also available to the the fundamental rights, very essential human rights to the. You can just go through this particular slide. These are the main different. You can divide the fundamental rights into the 6 different categories. Right to equality. So Article 12 to 35. That's relating to. Now this part is very interesting for all of you. Right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, right to constitutional remedies. So fundamental rights, it protects the rights and liberties of the people against the arbitrary power, very essential for the growth of the individual personality and to achieve the welfare of the people, public at large. They establish the government of law and government and not of a man. As I said earlier, there is a rule of the law. Whosoever the government is in power, you are subjected to the limits of the constitution. That means you cannot come up with a law, you cannot pass a law which can abridge the fundamental right of a citizen. When we started today, I had given you the example that suppose tomorrow government of Gujarat comes up that you have to take a prior permission for visiting a state of Rajasthan. Now see, it's a different scenario, right? In COVID era, you know that every state has, of course, now the COVID situation is far better by God's grace. But remember the time of the lockdown and after the unlock, all the whatever the unlock process was started. In that unlock process also, every state has different rules they have kept. Some conditions they have kept. Some say you have to undergo the RT-PCR. Some states you have to be for 15 days, you will be quarantined. So that's a altogether different thing what is happening specifically for the COVID time. I am not on that particular, forget about this critical pandemic situation. But in our normal days, if any of the state says that you cannot enter state, say Madhya Pradesh, you have to take a prior permission. You can't do that. And if any sort of law that is passed on that effect, that can be challenged in the court of law. And that is what we say, that the right to the constitutional remedies. One can challenge it. When one can challenge? When you have knowledge. When you know that my fundamental right is violated. So it is very essential to have the knowledge of the rights first. Because if you do not have the knowledge of the right, because see, when we say for the justice, that the justice, or when you ask for the justice, then you need to have the feeling of injustice. If you don't have the sense of the injustice, how come you can ask for your rights? Because you don't have any sense of injustice. If you feel that everything is fine, then you will never question it. But to have the sense of injustice, you need to know that what are your rights. And then only you come to know that yes, this particular right has been violated. And the right which is violated, so that means that the remedy that you get, that is against the state. The law which is passed by the state and you as a citizen, you can question that law. And under the constitution, you will question on the basis that this right is violated because this violates my particular fundamental right. It abridges my fundamental right, and you can go to the court of law and request the court to declare it to be ultra vires. And court, there are many judgments where the court will declare and has declared that it is ultra vires. Ultra vires means it is not in conformity, not in consonance with the constitution. So they declare that this law is not in consonance with the constitution. So it is declared to be void. Many instances, many examples, many case laws we will take up as we go ahead. But here, what I wish you to understand are 2-3 fundamental things that you need to know. That you take up any of the law, you have number of rights under various statutes. But under the Constitution of India, these are the fundamental rights which by birth you are getting. And these fundamental rights are the fundamental in our day-to-day life. The reason being, it's a protection, it's a shield that if any government comes up with any of the law and abridge whatever the rights you have here, right of equality, right to freedom, right against exploitation, freedom of religion, cultural and educational rights, all these fundamental rights, you are blessed with the Constitution of India. So you must know which fundamental rights you are enjoying. Say, for example, you take up the example nowadays, all of you, all the young generations, you are on the social media. You have Facebook, Twitter, and so on. Now, say for example, if you make one comment on the social media in context to the other person, there are a number of laws which come into the play. But say for example, one of your fundamental right under the Constitution is right of expression, to express your right. Now, it is not something that whenever we talk for any of the right, then that right has no limit also. Even your rights also have some limits. As I said, that when government passes any of the law, it has to be in consonance with the Constitution. And the Constitution very well balance your fundamental rights also with the reasonable restrictions. So that when we take up each of the different rights, at that time you will come to know. So we can broadly, we can divide the fundamental rights into this different categories: right to equality, right to freedom. Now which, let us take the first one, the right to equality. Now for right to equality, friends, right to equality you can see from Article 14 to 18. And right to equality is always contemplated that equality before law and equal protection of law. But here it is not something like that we talk of the mathematics kind of equality. When we say the right to equality, you know that right now there is a lot of debate which is going on for the marriage age of a male and a female. You must be aware. The marriage age for a boy is 21 and the marriage age for a girl is 18 years. Now, when we talk for the right to equality, here the right to equality is not in context to then why not 18 years for the boy also? Right now, lot of debate is going on, and it seems that it will change very soon. It seems so. But my question is, I want you to understand that when you say the right to equality, that right to equality is equal protection of law, equal protection, equality before the law. But you cannot say that it as the mathematics kind of. Say, for example, if X person is getting the Z plus security, and if I say that I also need to have the Z plus security, I have a right to equality, I have a fundamental right. No, you cannot claim right to equality in context to kind of the mathematical equality. It is the concept of equality is equality amongst the equals. Equality amongst equals. So the Article 14 that it talks for the equality of law and the equal protection, equality before the law and equal protection of law to everyone. There are, as I say, there are always certain exceptions to the rule. Here you can see that the exceptions, say for example, you can just go through that the president and governors are not answerable in any of the courts. Members of the armed force are controlled by military force, navy and medical practitioners. Police officer has the power to arrest. Say the laws made by the state for implementation of the directive principles under Article 31C. These are all, if challenged, Article 14 will not be applicable at times. So as what I want to make a point here is that if you are the president, if you are the public office, and you are enjoying certain of the rights, so there you cannot question it as a part of the right to equality. But the equality amongst the equals, that is what is, even if there is an emergency that is declared under the Article 359, the right to approach the court under Article 14 shall also, is also suspended. The foreign sovereign, the ambassadors, they are also exempted from the judicial process. So these are a few of the, as a part of the public office, they enjoy this particular position, and there you cannot question as a part of the right to equality. I hope you understand the basics of the right to equality. There's a recent judgment that you must have read in the newspaper also, the Sabrimala judgment, so far as the gender justice is also concerned. There's a lot of hue and cry, that the Sabrimala temple, the women from 10 to 50 years, they were not allowed to have the entry to the temple, and that was, you can see here, Indian Young Lawyers Associations, they filed a petition, and in that, that particular rule of that temple pertaining to the no entry to the women for the, it was on the ground of the Article 14 that it is discriminatory for not giving any entry to the women. So it's a discrimination, and devotion cannot be subjected to the gender discrimination. So that's the judgment of the Indian Young Lawyers Association. And now it is, but see friends, that judgment is, here you can see, of course you all are not the law students, but it is very interesting to know that out of the 5 judges, one of the judge who was a female judge has given the concurrent, there is no concurrence from her. It's a dissenting judgment. She has dissented. There is a dissenting judgment of a female judge. Very interesting to read. But the point that I want to make here is, that the entry of women. Now let us go beyond. If you correlate that with the basic fundamentals and your basic belief that even if on the part of as a part that this particular act is considered as a discriminatory, as a part of the faith, as a part of my religious practice, will I enter? This is also a question that we need to think on that. But if we see with the lens of the Constitution, with the lens of the right to equality, one cannot subject the women from the age of 10 to 50 for the gender discrimination. So this is also under Article 14, one of the recent judgments which you must be aware. The next is also the very landmark judgment. You know that Section 377 of the Indian Penal Code, which was declared as unconstitutional because it criminalizes the consensual sexual act of the adults in private. So this is also one of the judgment wherein also the right to equality, Article 14, has played a very vital role. And this is, you know that when there is a consensual sex, which is some unnatural or the homosexual act or something, so which was earlier it was considered as an offense, but with this recent judgment of Navdeep Singh Johar, now it is no more. It is considered as an offense. This is also one of the very important and very famous judgment. It's of 2018 judgment, Joseph Shine versus Union of India. And this is also the 150-year-old Section 497 of the Indian Penal Code, which is pertaining to the adultery. So husband is not the master of the wife. That's adultery, that 497. That is also declared as the unconstitutional. But of course, the court has clarified that the adultery will be a ground for the divorce, no doubt about it. So it's one of the valid ground for the divorce. But it was also stated that an act of the adultery leads the aggrieved spouse to suicide. The adulterous partner could be prosecuted for the abatement of the suicide under Section 306 of the IPC. Of course, we don't want to go into the detail of that, but only the point that I want to bring to your notice is that when we say that I have right to equality, then this is also, these are all the recent judgments. Even if I talk for the before this, one of the very famous judgment, Nargis Mirza, wherein you could find that in Indian Airlines, all these you know that there are air pursers and air hostesses in flights. So there was a rule under this Indian Airlines, their rules, service rules. One of the rule was that air hostess cannot marry in the first 4 years of the service, or if she attains the age of 35. Now, that was challenged in Supreme Court. And in that judgment, it was declared as to be ultra-virus, and it was declared, and Justice V.R. Krishna Iyer was the judge in that particular case. It's a very famous case, Nargis Mirza versus Union of India. This is a renowned watershed judgment on the part of the right to equality, because how can you treat the women, the air hostesses, on a different? This is a sheer discrimination under the Article 14. Because if you are a male purser, you don't have any problem. But if you're an air hostess, then this kind of provisions you could find. There's one another case also, very famous case, that was also pertaining to the Indian Foreign Services, wherein one of the clause under the Indian Foreign Services was that if there is any female who is in service under the Indian Foreign Service Act, then if she gets married, she has to take prior permission from the department. You have to take a prior permission from the department, and if the department feels that your marriage will not come into the your services, then only you will be given the promotion. So there was a one C.B. Muthamma, one IFS officer, was denied the promotion because of her marriage, and which was challenged in Supreme Court, and it was declared as to be discriminatory. Now, friends, this is what you find, that there are number of rules, number of act under which there are so many rules wherein you find that discrimination takes place. Now, it is not something that somebody needs to question, and you need to understand that there is some discrimination. If you do not have the knowledge that you have the fundamental right of equality, how will you question that? And it was the C.B. Muthamma who questioned after so many years. That rule was from 1951, but it was challenged in the year 1979 or 81. So for all these years, it was valid, but somebody dared to question that. And that's what is the power as a citizen that we enjoy, that we have right to question. And we have, especially when there is violation of the fundamental rights, we can very well question in court of law. So we go ahead with that. Now, with if you see the right to equality is not only Article 14, but 15, 16, 17, 18. There's an entire total club of. It is extended in a one thread itself. You find the right to equality. So 14 says that everyone is equal before the law, and equality before the law, and equal protection of the law. It is extended under Article 15 that the state no person shall be discriminated on the basis of caste, color, language. Let's say, for example, if I visit a temple, somebody cannot, suppose on basis of my caste, if somebody says that you don't enter this particular place, or if I am going to this Auda garden, and somebody says that no, you cannot enter this public place or this public garden because you belong to a particular caste. So Article 15 envisages that no person shall be discriminated on the basis of caste, color, language, because every person has the equal access for all the public parks, all the public places. You have the access to the public places. But at the same time, though state should not discriminate, but there are few exceptions to that, and that is that in favor of women and in favor of children, one can do that. One can means the government. Government is empowered to have the special laws pertaining to women and children, and that is why many a times, on the lighter side, I am saying that at times, when you talk for the gender justice and all that, then there is always a debate why you need 33% reservation. But that's a special provisions that are, of course, 33% we find only for the panchayats, not in parliament or the state legislatures. There's yet to come. But why you need? That's altogether a different aspect. But 15 says a special. For example, you are you are traveling by bus. In bus also you will find that reserved for women or reserved for children. You go travel by train, you travel by buses. So these are all public properties, public places. But even though you find that special reservation in favor of women and children, so that is permissible under Article 15 of the Constitution. Article 16 is relating to the equality notion, which is extended under Article 16, and that is under the right to equality for the public employment. So again, 14, right to equality. 15 says that on basis of caste, on basis of that, one cannot discriminate the right to equality, but there can be special provisions in favor to women and children. Again, for the public employment also, the Constitution lays down that the state cannot discriminate anyone in matters of employment. All citizens can apply for the government jobs. So that is also one of the important fundamental right that all of us we enjoy. Then there is another fundamental right that is relating to the abolition of untouchability. It abolishes the practices of untouchability, because practice of untouchability is an offense and it is punishable by law. And this is one interesting judgment. It's one of the rule at the Punjab University that was relating to where there is a affiliated institute, a women college, then the appointment of the lady teacher or the lady principal, that was the rule that the principal should be a female, which was challenged, and that this is a violation of the fundamental right. It is discriminatory whether the principal is a male or the female. But the Supreme Court held that it is not violative of Article 14 or 15. It is a reasonable classification for the certain post. So it is always, if you see that if there is a women college or the women university, you always find that the head of the institution is also women, or the vice chancellors will be women. The reason being, it's one sort of preventing and protective measure, which in context to the public morals. So this is also one of the judgment that you must know. We don't want to go into the details of this. Article 19 is also as a part of the one thread of the fundamental right is abolition of the titles, and Article 18 that prohibits the state from conferring any of the titles. So citizen of India cannot accept titles from a foreign state. Now this is again another set of rights, and that is rights against the exploitation, and you can find here that is also one of the fundamental right. It is for the safeguard of women and children and others against the exploitation of the various forms. It is against the human trafficking. Article 14 is relating to against the child labor. Now, another set of the fundamental rights that you find from Article 25 to 28, freedom of religion. Now, this is a very interesting fundamental right. Now, if you see the language of Article 25, that it gives you the freedom of conscience first. State has no religion. We say that the India is a secular state. So state has no religion, number one. Number two, that we respect each and every religion. And it is the fundamental right of any person to practice any of the religion. Now, what exactly this particular right in toto we will discuss 25, 26, 27 and 28. The first is you have the right of conscience, freedom of conscience. Then whatever the freedom of your conscience is when you say that freedom of conscience, even though if you belong to in your house only, you just try to think that your parents may have belief in Sai Baba, but you may have a belief in Gayatri. You may have belief in Swaminarayan. You may have belief in any of the other god or the goddesses. So whenever it's basically, it is with your conscience that somebody, there is puja of goddess in your home, but you believe in Mahadev. So that depends. You may practice any of the religion. You may have faith in some other religion as well. This is what examples I am giving. I am giving examples intersect. But you may have the other religion also. You may have belief. So the first freedom as a person, as a citizen of this country, we enjoy the freedom of conscience. Now, when you have a freedom of conscience and you believe in some God, then once you believe, then we always, we profess. We profess, then you have freedom of practice. You practice that particular religion. When you practice that religion, then you want to propagate that religion. You want to, talk about it. You will tell your friends also. You will tell your society people, other people also. Because now you want to propagate. So first it starts from your conscience. Because that is, when you talk for the freedom of conscience, it is something your spiritual conviction. And that spiritual conviction you have at the level, it's your conscience. Then it will be converted into words. Then it will be converted into action. And what you believe, first you share with your friends, then you share with your community, you share with the world. So now you want to propagate that particular religion. Okay. So that's what is when we take it that I have a fundamental right of religion, then fundamental right of religion is not only, it's a fundamental freedom of my conscience in the religion what I believe. After that, I will profess, I propagate, I practice, and then I propagate that particular religion. But then, the another set of you can see here that, of course, these are the restrictions on the freedom of the religion. You cannot there cannot be forced conversion and all that. Now, this is also one of your fundamental right to manage the religion affairs, and for that, if you need to establish, see, first again, let us go back. Your conscience, you profess one religion, you practice that religion, and then you want to propagate that religion. So now I want to propagate that particular religion, then I need to have the institutes pertaining to it. And so that Article 26G empowers you to establish and maintain the institutions for the religious and the charitable purpose. So you can manage its affairs in matter of religion. You can own, you can acquire the properties, you can administer those properties in accordance with the law. With 26 also, the 27 is also on the same thread. You can find that the taxes, so freedom from taxes for promotion of any particular religion. So you get tax relief for that. And then the Article 28 comes, that the prohibition of religious instructions in state-aided institutions. So that's one restriction, one prohibition under Article 28, that fine, but if there is this, the institution is a state-aided institution, because the state has no religion. So state will, if there is any funding, any aid which you are getting from the state, so state-aided institutions cannot have the religious instructions in that institute. So this is what we, under the Constitution of India, the right of religion that you find, it's not only Article 25, it is entire set of articles from 25 to 28 that you find. We go further with the cultural and the educational rights. That this is also under Article 29 and 30, and it is right to cultural and the educational rights of the minority groups. So, okay, now here under Article 29 and 30, when we say for the minority groups, then the cultural minority, cultural and the educational rights to that particular minority. But that minority is considered on what basis? And that is the conserving their culture, language and script. The provision simply states the citizens have right to preserve their language, heritage and backgrounds, cannot be stifled by major language groups, and no minority groups will be denied admission into an educational system or institution of their choice, and will also not be deprived of any funds from the state purely based on religion, caste and language. Now here, and Article 30 is relating to the right to establish the educational institutions. Now, right to establish the educational institution is also right extended to for the minorities, and that is also you can administer and you can start your own educational institutions. The government will not deny these institutions any state funds or aid on the basis that they are run and managed by the minority groups. There are many judgments, many renowned judgments on these particular aspects, but we cannot discuss here. The object is just you to know that these are the fundamental rights. So we go ahead. These are the few of the judgments. Again, The another set of right to freedom, that's Article 19, that you find there are certain freedoms that as a citizen of this country we enjoy: the freedom of speech and expression, freedom to assemble peacefully without arms, freedom to form associations and unions, freedom to move freely throughout the geographical boundary of the country or the territory of the one country, freedom to reside and settle in any part of the territory of India. These are all the fundamental rights that we find. And Article 19 to 22, as I said, friends, is pertaining to the extended 19, 20, 21, 22. These are all pertaining to the certain freedoms. To practice any profession or to carry on any occupation, trade or business is also one of your fundamental right. Right to property was earlier, it was part of your fundamental right, but now it is, after 44th Amendment, it is not fundamental right. It's merely a constitutional right to property. So these are the certain freedoms that you enjoy from 19 to 22. Now this is the freedom of expression. These are some of the exceptions: that in respect of the sovereignty and the integrity of the country, there may be the restrictions: security, for the security of the state, for the friendly relations with the foreign states, for the public order. It depends. On the ground of decency and morality, contempt of court, defamation, incitement of offense, sovereignty, integrity of India. So these are the exceptions to the rule. We don't want to go into the details of the cases. Article 20 is also one of the fundamental right, which is called as a doctrine of double jeopardy. Article 21 is considered to be the soul of the Constitution of India, that no person shall be deprived of his life or personal liberty except according to the procedure established by law. And this is the one word that you can find here on the slide: the word life and the personal liberty. The word life, is interpreted by the Indian judiciary in a manner that this one word, there are so many rights that has emerged from this one word. For example, if we talk for the right to education. Right to education was not earlier fundamental right. Nowadays, it's a fundamental right. The reason being, it was interpreted by the judiciary that because when we say that I have a right to life, મને જીવન જીવવાનો મારો મૂળભૂત અધિકાર છે. I have right to life. So if I say that right to life is my fundamental right, then the interpretation was given by the judiciary that if I want a meaningful life, then I need livelihood. If I need livelihood, I need education. Because without education, I cannot get livelihood, I cannot get work, and so I cannot enjoy my life, I cannot have the meaningful life. So if the right to life is my fundamental right, then right to education is also the integral part of right to life. which was recognized by the Supreme Court of India. And now, friends, you know very well that from 6 to 14 years of education is considered as the free education it's a fundamental right and state should provide. So Article 21A was specifically added to the Constitution. That's the right to life and personal liberty. Many rights that are enumerated. Say, for example, the recent Aadhaar card judgment, that also the right to privacy, which is recognized by the Apex Court. I hope you all are aware of it, a right to privacy. But if you look into the earlier judgments also, recently it is explicitly announced by the Apex Court that right to privacy is fundamental right under Article 21, right to life. Because privacy is also one of the very important facets of the life. Now, there are different facets of life. So if you say that the life is a fundamental right, so every facet which is relating to life is also the fundamental right. For example, if I say that pollution-free environment, then that is also my fundamental right. If I don't have a good pollution-free air to breathe, if I don't have the water to drink, if somebody gives me a raid water or the water with the effluents, how can I drink? How can I survive? So I need a clean water to drink. I need clean air to breathe. Then only I can survive. So it is an integral part of my life. So by way of that, to have the pollution-free environment is also my fundamental right. Now, friends, you may have questioned that, okay, right to pollution-free environment is the fundamental right, or right to education is a fundamental right. But why it is important to interpret that all these different facets of life are also integral part of fundamental right? The reason being, it empowers you to question the state. So if any of your important aspect, the facet pertaining to life, is abridged by any of the means by the state or the administrative authority, it empowers you. It empowers you with the constitutional remedy under Article 32, where you can question. A common man has power to question, and that power, the source, is the fundamental rights. And the most important aspect to exercise that is to have the knowledge about it. And that is the reason that this is part of your curriculum, that you know that these are all your fundamental rights. These are few of the fundamental rights which are declared by the Apex Court as a part of the fundamental right. Now we go further with, of course, there is a paucity of time. Only the one thing, very, very quickly, what I want to bring to the notice of all of you. I have taken much time for the fundamental rights because my intention was that you know that what are your fundamental rights that you enjoy. You enjoy number of rights under various statutes, but fundamental rights are the fundamental because it empowers you to go directly, it empowers you with the remedy under Article 32 to go before the highest court of the country. This is the one very fundamental thing. And these rights you get against the state, no one can abridge these rights. No one can pass a law which can abridge all these rights. And you as a citizen are required to question. Now, I always find that there are counter arguments that there is a delay in justice If you go to the court, it takes long time. There are all the different theories of it. But there are the examples which I have given. There was a one judgment wherein in the advertisement in state of Maharashtra, this is not a story, this is a reported judgment of the Supreme Court. A one advertisement in the newspaper was given that if for a public employment, if the women candidates are applying, then they must submit the no objection certificate, NOC, from the husband, which was challenged by one lady, Madhu Narayan, versus state of Maharashtra. This is the name of the case, which was challenged. The examples which I had given you, the C.B. Muthamma, Nargis Mirza, or for the matter, the recent one of the Sabrimala, the Young Association of the Association of the Young Lawyers. If you don't question, then you are always subjected to the injustices. So the basic object of the justice at every level, socio-economic, political, we cannot, that is not possible unless we exercise our rights. Now, the another important part under the Constitution is the Part 4 of the Constitution of India, the directive principles of the state policy. So these are all the name itself, it suggests, they are the directives given to the government that these principles the government must incorporate in its governance. Now, if the government do not incorporate, then you cannot bring any of the action against it because it is not justiciable. It is not a fundamental rights part where it is justiciable. But if you find the directive principles of the state policy, you will find that it is not justiciable. So something which is not justiciable, you cannot question in court of law. But there are number of judgments wherein the court has read the fundamental rights under the directive principles of the state policy. And even there are so many, I would say, the legislative activism also, that to fulfill all these, whatever the principles are given under the directive principles of the state policy, that is also incorporated into the by act. Say, for example, the equal remuneration for the equal work. So all these kind of payments, so far as no discrimination. So that act was enacted in the year 1976. So basically, if you see the entire, under the Constitution, it is basically the functioning. Like, say, for example, center and state relationship. But there are a number of judgments, there are few articles under the Constitution for the, even the interstate relations you find. There are many interstate disputes as well. If you think in context to Gujarat, and if you know the history, you know that the Narmada dam, that was because we had lot of issue with the Madhya Pradesh, because ultimately that comes from the Amarkantak, and the origin is in MP, and then there were lot of issues with the other adjoining state as well. Take up the issues pertaining to the Kaveri River also in south. So the states and center relationship, the subject on which the state has enacted a law on the same subject, the same entry, and the central has also enacted a law, always the law of the central, the law of the parliament prevails when there is a controversy. This is the fundamental cardinal principle, that the law of the center prevails over the state law on the same subject. So that is one another important aspect that you must know. You know the president, the power of the president, the functions of the presidents and so on. But ultimately, the constitution is the powerhouse for any of the citizen of the country, that you can exercise that. And even if you find the Indian judiciary has also played a vital role by interpreting the dead words of the constitution in a manner that many new rights have emerged. Not only that, the part which was not justiciable is made justiciable, and some of the creativity, I would say, the gift given to the citizen of this country. For example, say the public interest litigation. You don't find the word public interest litigation under the Constitution of India, 448 articles. There is not a single word like public interest litigation. But today, if you go to the High Court of Gujarat, or for that matter, any of the state, you will find that in a 1 week, 1 or 2 days are specially allotted for the PILs. So public interest litigation is the creativity of the higher judiciary, wherein the locus standi is expanded. For example, I have some dispute in some matter. Then, being an aggrieved party, I have the right to go before the court of law and ask for the justice. But say, for example, in your SMP, your first year class, or there is a particular class, say students of SMP. Now you want to do something, and you find that the fundamental right of the students or the children here in Gulbai Tekra near you find that Hollywood, that area, and you want to do something, and you want to bring to the notice of the court and ask for the justice on behalf of them, then it is possible. When for any of the public cause, for the public interest, for a particular class of people, aggrieved class of people, one can file a litigation in court of law. It is called, in legal term, it is called as expansion of the locus standi. You can expand the locus standi. So there is expansion of the locus standi by way of that. There are many other, there is independent judiciary, there are specific provisions, the powers, the appointment, the transfer of the judges, that everything we find under the Constitution. And so far as you all are the commerce students, I will share the PPTs with Joki sir or Nashal ma'am, that for the trade also, the specific provisions under the Constitution that are pertaining to it, because due to the paucity of time, I won't be able to go much into the details of that. That also, it is very essential that you must know. And I do expect, and I wish that each one of you must be aware of all of your fundamental rights, and you must exercise when there is a violation of any of your right, you must question. It is very essential as a citizen of this country, because when we talk for the democracy, the law is one of the very important dimension for the protection of the democracy. And for that, I think that the judiciary is the last resort, and there is always expected and the hope on the judiciary for that matter. But it is our duty to question if there is any sort of injustice that we are subjected, or anyone around us. If we find that somebody is subjected to the injustice, it is our duty to question. With that note, I end my presentation over here. and Ashalben, I hope you are very much there. And my time is also up. I have exceeded 15 minutes. I'm sorry for that. Ashalben, hope you can hear me.
It is absolutely fine, ma'am, because the way you presented the fundamental rights and the concepts in such a great detail, it was so nice to have you, ma'am. I will request my colleague, Dr. Bhavik Swadhya, to propose a vote of thanks. Over to you, Bhavik, ma'am. Bhavik, sir.
Good afternoon, ma'am. Good afternoon, all. As we come to the closure of this expert session.
I'm sorry. Sorry, I'm interrupting you, but I forgot to give my email ID to the students. You can share it with the students if they have any query, any questions pertaining to this particular module, their syllabus, or any query pertaining to law. They can send me. They can ask me.
Sure, ma'am. Sure.
Ma'am, students are also requesting if you can share the PPT as well, because they couldn't see the slides.
100%.
Thank you so much. Thank you. Yeah.
Again, good afternoon, ma'am. Good afternoon, all. As we come to the closure of this expert session, I take this opportunity to propose a vote of thanks to one and all who have helped in making this event such a resounding success. First and foremost, I thank our special guest, Dr. Mayuri H. Pandya ma'am, who, despite of her busy schedule, has found time to grace this occasion and deliver a wonderful lecture. Thank you, ma'am. I also thank my colleagues for their consistent cooperation. Thank you all. Goodbye. Have a nice day. Thank you, madam. Thanks again. Thanks again, ma'am.
Thank you, ma'am. Thank you so much. Have a nice day.